Okay, well, looks like we have a number of people that are registered. I think we're reaching critical mass, so we're going to start today's webinar. Good morning and welcome. Thanks to all of you for joining us for today's webinar focused on OSHA's new vaccination rule issued on Thursday, November 4th. My name is Jason Castor, and I'm the Chief Business Development Officer for Parsons Behle Latimer, and I'd like to welcome you to today's webinar. Given the complexity and the potential impacts of OSHA's new rule on employers with more than 100 employees, it's not a surprise that we have more than 240 people registered for today's call. Our objective is for you to walk away from today's webinar with a better understanding of what types of employees are affected by the rule, how to keep track of vaccinated employees, alternative testing requirements, compensation requirements, religious and disability exemptions, and other practical guidelines to help you navigate this challenging issue. Before I introduce our panel, I'd like to cover just a couple of quick housekeeping items. First, today's presentation is being recorded, and you will be provided with a link along with a copy of today's PowerPoint presentation to share with your colleagues and teams. Second, we would like for today's webinar to be as interactive as it possibly can be in a virtual environment. With that being said, please feel free to submit your questions using the chat feature. Throughout our discussion, we will do our very best to address your questions. When you submit questions via chat, please submit them to all attendees or to the panelists so everybody can see the questions. And finally, the important legal disclaimer that we always have to cover. Today's presentation is considered a general source of information and is not intended and will not serve as a substitute for legal counsel. Given the complexity and rapidly changing landscape, you must consult with your legal counsel on these issues. And with that, I would like to welcome our three panelists. Christina Hardesty is the Director of Legal from Amalgamated Sugar Company in Boise, Idaho, who is going to lend a unique perspective from a corporate standpoint today. Christina, thanks so much for being with us. Amy Lombardo is a shareholder from the firm's Boise office. She advises clients on regulatory matters, employment law issues, and government relations. And Sean Monson is a shareholder from the firm's Salt Lake City office and chair of the firm's employment and labor practice. He focuses his practice on employment counseling and litigation. So I know we've got a lot to unpack today, so let's jump right in. And just as a reminder, for those of you that just joined us, please remember to submit your questions via the chat feature. We'll do our very best to address those throughout the presentation. If we can't get to your question, we're more than happy to connect with you offline. So Sean, I'm going to turn the time to you to kick off today's presentation. And again, big thanks to all of our panelists for their willingness to participate today, for providing the information that we're going to share. Sean, I'll turn the time to you.
All right, thanks, Jason. So as Jason said, if you have any questions, please submit them in the chat form. We'll do our best to answer them. If we can't answer a question that you have, please feel free to send us an email. Either Amy or I, and we will do our best to answer that question by email. Next slide, Jason. All right, so what happened on November 5th? As you all know, on November 5th, the federal government issued an emergency temporary standard under OSHA. Essentially, the OSHA Act allows OSHA to make emergency temporary standards similar to the one that happened on November 5th, when there is a potential grave danger to employee health and safety in the workplace. And essentially, OSHA has determined that COVID-19 represents such a grave danger. The ETS takes effect on November 5th. Enforcement begins on December 6th, except for the testing and vaccination components that Amy will be talking about later on. Enforcement of the testing and vaccination begins on January 4th, 2022. Because the ETS did not go under the ordinary rulemaking processes for OSHA, it only lasts for 6 months. So after the 6-month period, OSHA will either have to go through the normal rulemaking process and the rule will become final, or the rule will essentially expire or terminate. One interesting little caveat and little nuance that I want folks to be aware of, particularly folks that are in Utah and Nevada. Before the ETS was issued, and for years, different states have had their own safety plans that have been approved by the federal government. Those states then enforce the state plan. So essentially, the federal government says to states, here is the OSHA regulations, here's the OSHA guidelines. You can implement your own plan that will meet those guidelines, but then you as the state will enforce it. Some states have elected to have their own plans and to have their own enforcement mechanisms. Some states have elected not to do that. Utah and Nevada are two states that have their own plans. So with regard to states that have their own plans, their own OSHA plans, and their own enforcement mechanisms in place, rather than relying on the federal government, those states either have to change their plans to incorporate and adopt the ETS, or create or modify their OSHA plans in a way that will be at least effective as the ETS in keeping employees safe in the workplace from COVID-19. Those states have to do that within 30 days, and they have to notify the federal government within 15 days what they're going to do. The reason why I say that is if you're in Utah or Idaho, this ETS doesn't technically apply to you, because what's going to apply to you is a state rule, and the state rule is either going to be an adoption of the ETS rule or something that is going to be just as effective. What's the practical impact of that? I think the practical impact of that is probably minimal, because the state of Utah and the state of Nevada are likely to adopt the ETS standard. It's hard for me to envision them going through their own process and evaluation and testing and analysis to create standards that are similarly as effective as the ETS. I think they will just adopt the ETS if they're forced to do so. But that raises the next point, which is the ETS ever going to go into effect? Immediately after the ETS was issued, multiple states filed lawsuits, including Utah, Idaho, Montana, all filed lawsuits against the federal government regarding the applicability and the enforceability of this ETS. There was 4 different lawsuits that were essentially filed by 4 different groups of state groups. And they filed them in different Federal Circuit Court of Appeals. And the Fifth Circuit Court of Appeals, which is a court that has jurisdiction in federal cases arising in Texas and Louisiana, has stayed enforcement of the ETS. And even though the Fifth Circuit is essentially only governs southern states such as, again, Texas and Louisiana, the stay applies by its language nationwide. And so what's going to happen is all the cases that have been filed by all the different states are going to be consolidated into one case. There's a lottery system that is employed where that there will be one case where all the cases are consolidated, and that's likely to happen by November 16th. So by November 16th, there will be one court that is going to hear all these cases. It's all going to be consolidated into one. A lot of people think that after that consolidation happens on November 16th, there will be a decision by around Thanksgiving. Courts generally, I know that any of you that have had experience in litigation, courts can be frustratingly slow, but when needed, they can move very, very quickly. And I think this is a situation where judges understand the necessity to move quickly in reaching a decision about whether the ETS is enforceable or whether it is not enforceable. So our recommendation to employers that are looking at this ETS and thinking about how to navigate and what to do with the fact that you've got this standard implemented by OSHA, but then you've got all these lawsuits that are challenging its enforceability and its constitutionality. What we recommend is create your plan, get it in place, and then see what happens with the ETS. I think you're taking a real big risk if you are thinking, well, the court cases are likely going to find that this ETS is not going to be enforceable, so I'm not going to create my plan. Create your plan now, get it ready to go, and then ultimately, if courts decide that the ETS is not enforceable, then you can make the decision about what you want to do with vaccinations and testing. But if the courts then decide that the ETS is enforceable, you're ready to go and you're not behind the 8 ball and trying to scramble. Next slide. Okay, so what's the stated purpose of the ETS? The stated purpose of the ETS is to establish minimum standards for vaccination, verification of vaccination, face coverings, and testing requirements. And again, as I said at the outset, to address the grave danger that COVID presents to the workplace. That the OSHA has found that COVID presents a grave danger to the workplace. It's also very specific that it is intended to preempt state and local laws that interfere with the employer's authority to require those things listed above, such as vaccinations and face coverings and testing. There's been a number of states that have essentially prohibited employers from requiring vaccinations or requiring testing or requiring face coverings. One of the purposes, again, of this ETS is not only to try to improve workplace safety, but also to invalidate and to preempt those contrary state and local laws. The rules specifically reference various states that have implemented these type of rules and regulations prohibiting employers from testing, from requiring vaccinations, from requiring face coverings, such as Texas and Montana. Ultimately, whether there's a grave danger presented by COVID-19 will be decided by courts. It will be decided by the panel. Yeah, Amy.
Sorry to interrupt. We are trying to make this a little bit interactive, but hopefully not interrupting a lot. We do have one question that is a good one to take right now. It's actually on your last slide, and you had mentioned that Utah and Idaho both have legal challenges to this. But one area where Utah and Idaho are different is that Utah does have a state plan and Idaho does not. So Idaho will be under the federal standard. So the question is, does the ETS apply to public sector organizations in Utah? And to me, this is a little counterintuitive, but I think because Utah has the state plan in place, or will, public sector is affected, and in Idaho, public sector is not. The ETS
no, I
does
think
not
that's
apply.
right. Yeah, I would agree with that.
All right, just wanted to get that in there.
Yeah, great.
Go ahead.
Okay, thanks. Okay, next slide, Jason. So who are the covered employers that this ETS covers? And likely, like I said, when Utah and Nevada and other states that are state plan states implement their rules, who is going to be that are going to be the incorporation of the ETS, or they're going to be at least protective of the ETS? Who are the covered employers? So essentially, employers that are covered are employers that have 100 or more employees. Now, I say for now. The reason why I say for now is the rule talks about that OSHA is going to continuing to look and is asking for comments from the public about the efficacy and the ability for this rule to be applied to employers with fewer than 100 employees, so smaller employers. They're asking for public comment. I think that OSHA, the OSHA leadership wants to implement this rule for smaller employers with fewer employees, but they're asking for public comment. So I don't think that this is the end of this rule. End of the line, that if you're under 100 employees, you can say, okay, this rule doesn't apply to me. I think that there is a good chance that this rule will be amended to apply to smaller employers if it withstands the judicial challenges. So when you're doing this count, go back if you would, Jason. So when you're doing this count, part-time employees count, independent contractors do not count, and you count all the employees across the offices. So if you have 20 different offices that have 20 different employees in each office, then you're covered because you take all the employees in each office across the United States and you aggregate them. It's not like the Family Medical Leave Act where you have 50 employees within the 75-mile radius to cut off. It's any employees that work within the U.S. are counted for this 100 employee count. What do you do about related entities? And that is if you have one entity that has maybe different subsidiaries or different common ownership. So what the ETS says is that if related entities are counted as a single employer if it handles safety matters as one company. So if all safety matters are handled in a consolidated manner by kind of one mothership, as it were, then all the related entities are going to be counted as a single employer. There's no guidance on what safety, quote unquote, safety matters means. There's no guidance on whether the integrated operations doctrine or other tests from other federal statutes are going to apply. This is all we have, is that if there is, if safety matters are handled as one company, then all the related entities are going to be included in this. And so if all those related entities have 100 employees, then all of them are going to be covered by the ETS. Next slide. So here's some considerations to think about when you're thinking about that in single employer test. How interrelated are the employers with regard to safety issues? Do you have one safety director, or do you have one for each entity? How have any prior OSHA complaints been handled? Have they been handled by the mothership, or they've been handled by each individual entity separately? Do you have one safety policy that applies to all the related entities, or does each entity have its own safety policy? Those are some of the considerations that I think will probably be relevant or applicable when deciding whether an employer is a single employer under the ETS. Another consideration that you might want to think about or look at is how do you handle this? How do you look at this under other federal laws like the Fair Labor Standards Act, Title VII, ADA? How does the integrated employer doctrine that's applicable in those contexts, how does it fit within your organization? Again, OSHA has not specifically said that it's going to adopt those tests, but I think it's important to look at that and think and have those tests in mind when you're considering whether you're going to be a single employer for purposes of the ETS or not. Next slide. Okay, so this is kind of interesting too. It's a one-way street on employer coverage. If you have 100 employees or more as of November 5th, you are covered by this ETS. Regardless if your workforce drops by 90 people the next week, you're still covered. It's as of November 5th, if you were covered through the whole duration of the ETS. If you are not covered as of November 5th, but at some point you do have, you hire more people and you have 100 or more employees, then you become covered. And so the issue in that instance would be, suppose you have 90 employees, right, as of November 5th, you're not covered, you hire 20 more, so now you have 110, and you do that on January 10th after all the compliance deadlines have passed, what's the status? You're covered by the ETS, but what deadlines do you have to comply? That's really not clear under the ETS. My best guess would be is that, and again, this is just kind of licking my finger and sticking it up in the air and seeing how the wind blows. But I think that once you are covered, once you get past that 100 employee threshold, my sense is that the deadlines that were ordinarily, the time gap from November 5th to December 6th, and then for compliance with all the regulations except for testing and vaccination, and then the time period to January 4th for compliance with testing and vaccination, those time periods would then be start once you pass that 100 employee threshold. But again, that's my best guess. There's nothing in the guidance that says that, but that would seem fair to me, and I think that's how a court would look at that being as being a fair approach. Okay, so one little caveat is the employer coverage versus the employee coverage. It's different. So any employees count, again, part-time, full-time, towards the 100 employee threshold, but they might meet, but those employees, but not all the 100 employees, might not be covered by the ETS. So, for example, if you have 101 employees, and Amy's going to talk about this a little bit later, but if you have 101 employees and 99 of them work exclusively outside, those 99 employees are exempt from being covered by the ETS. They don't have to be tested. They don't have to be vaccinated. But even though those 99 employees who work exclusively outside don't have to be vaccinated or tested, they still count for coverage. So the employer is subject to the ETS, but it only has 2 employees in this scenario that have to be vaccinated or tested that the ETS will apply to. And the final point on employee counts is that staffing company employees do not count as client employees. So if you've got a staffing company that's sending workers over and to an office or to a construction site or to whatever kind of manufacturer, those staffing company employees do not count for with regards to the client. They count for with regards to the staffing company. Okay, next slide. And this is a couple final points, is the ETS does not apply to federal contractors because they have their own rules. It also doesn't apply to healthcare settings, either medical or dental, because they have their own rules that are applicable. So those are two kind of exceptions for employers that are not covered by this ETS, and the reason why they're not covered by this ETS is because they're covered by other federal regulations. Next slide. Okay, I'm done, and we'll now have Amy.
So we've looked at the employees or the employers who may not be covered, but there are also employees, as Sean mentioned, who may not be covered. So the test here is basically if you are working around nobody, then you're not covered by the ETS. So if your your satellite office in Antarctica might be fine, and it's coworkers or customers. So it's also similarly those who are working from home, those are counted in terms of do we have 100 employees, but they are not counted for the question of do I have to be vaccinated or tested. However, if they come to the office for any reason, if they have to visit your home base mothership for some, corporate retreat, you have to have them make sure they're vaccinated or tested, depending on what your policy says, within 7 days of them coming into the office. So there's also an exclusion for employees who work exclusively outdoors. And that was oddly specific. Like if you are a construction worker who goes indoors just for a restroom, or if you have a porta potty, you're maybe an exclusively outdoor worker. But if you are outdoors except for the hour-long meeting with your team in the morning, or outdoors except for your lunch with coworkers inside, then you are not exclusively outdoors. So that is looked at carefully. Next slide.
Hey, Amy, what happens if you are working from home part-time and you come into the office, like maybe you work from home for 2 weeks and you come into the office for a week, and you can work from home for 3 weeks, come to the office a week. What happens in that situation?
If you're an employer that has just the vaccination policy plan, then you have to be vaccinated before you come in, fully vaccinated. If you are tested, if you're in the testing plan or the vaccination and testing plan, then you have to be tested within 7 days of going in. So let's get into what does the ETS cover. We've talked about who's covered. What does it actually tell you that you have to do? You have to set up, if you have 100 employees, a mandatory vaccination program, and this is done, I think in part so that it looks like it's not a full mandate, right? This will give the administration a little bit more leeway in their lawsuits. If they can say, we have a mandatory vaccination policy requirement, but we also have a testing and face covering requirement if you don't want to go the full vaccination requirement route. And I will also say that Sean will get into this a lot later, and I hope I can talk fast enough so that he'll have time to do so. The mandatory vaccination program, you can, of course, still have exclusions for ADA exemptions and religious exemptions. Okay, next slide. So you are required under this ETS to have a vaccination policy. You have to establish it, implement it, and enforce it. So the policy must be written. You can email me if you want a list of everything that must be in the policy. It's a lot, too large for the slides. OSHA would like you to encourage vaccinations, explain the importance of vaccinations, include how and where to get vaccinations and testing, and how it will be done, who the results should be turned into. And one thing I want to mention, we have been talking a lot about this January deadline. But the January deadline, in order to meet it, and if you look at what OSHA says, the only thing that is in January is the testing. So what you have to do well in advance of January is figure out who's vaccinated and who's not. Ask people to start getting vaccinated, because starting in January, early January, that's when you have to start the weekly testing. So if you don't have all of the information collected in advance, then you would just have to, you're supposed to have your policy, then you'd be sending everyone to get tested, including people who don't need to. And you wouldn't be in compliance because you wouldn't have a policy yet. Okay, so if you have time, the policy should be socialized with your employees as usual, as you would do with any new policy, and roll it out in advance. But given the timeline, this will be tricky. So you have to determine the vaccination status of each employee. Full vaccination is defined, of course. We all know that definition by now. But for these purposes, by January, you have to have had the 2 shots. You do not have to have waited the 2 weeks after the 2 shots. Next slide, Jason. There are specific guidelines on collecting proof of vaccinations. And so you can have someone bring in a copy of their vaccination card. You can have if your medical provider has this information, you can get a copy of information from there. You can check with your state or local health district and see if they have the information. Anything that's official and says that which vaccine was administered, the date, the name of the provider. And if an employee is unable to provide proof, they first have to go and look for it. And then they have to sign an attestation saying, yes, I was vaccinated. And these are all the details of that vaccination. And that attestation is specific. It also includes a statement that you understand that there may be criminal penalties for lying. Okay.
Hey, Amy, just
yes.
a question. So for the vaccination records, we have to collect information from every employee, right? It's not a voluntary, I want to submit my proof of vaccination. We need to know every employee's vaccination status, right?
Yes.
And then what if an employee declines to answer? Do we treat them as unvaccinated?
Yes. So perfect timing, because we'll talk about enforcement right now. You should be treated as unvaccinated if you can't or won't locate your information or are not vaccinated. And your policy, your written policy, has to include consequences for non-compliance. I'll get to this, but Derek, you do need to keep a copy of the card. It needs to be in a form that you receive and keep, and that you're able to show other people quickly later, including that particular employee and including OSHA. your enforcement mechanisms in your policy, there's a little bit of leeway there. You don't have to say, you know, 0 tolerance, you're fired tomorrow. But you should consider it, and there should be steps. This entire program is obviously designed so that people will get vaccinated, and so enforcement is an important part. The penalties are severe for non-enforcement, and here I will talk about how they're going to go about enforcement a little bit. So we don't necessarily imagine that an OSHA inspector is going to show up at every company's door in December or January, but you don't want to be the unlucky one either. OSHA obviously doesn't have enough inspectors to go out and check on everyone, but the way they can enforce this, as part of a regular inspection, they can also ask to see your log of all employees. They can also do it by phone. And when we get to the records piece, I'll explain that employees are able to receive their own record if they request, and an aggregate of information from their own work site. So if employees know that the whole work site is not vaccinated and doesn't see a lot of people, you know, masked and being testing, then employees can also report to OSHA. And that is going to be one of their important ways for enforcement as well. Okay, next. So paid time off. You are required, and this is a little tricky, just if you have any questions, double check the regulations because it's different for each part of the regulation. So you do have to provide reasonable time off for people to go get vaccinated. It's up to 4 hours. It doesn't have to be 4 hours. And it can be more than 4 hours can be requested, and you should take that into account, figure out why they need more than 4 hours. I don't know who needs to drive more than 2 hours back and forth to get vaccinated, but could happen. 4 hours is the cap for payments, so you don't have to have any more than that. But you can grant more unprotected or unpaid leave if they need more than 4 hours. And then you cannot require them to use accrued paid leave for the vaccination. This is 4 hours for each dose, has to be paid by the employer. And then up to 2 work days of sick leave following each dose. So you can, in this case, use an employee's sick leave first. But if they're out, or if you don't already grant sick leave, then you need to provide them 2 days, up to 2 days of sick leave. Then the question on paying for, and I saw one of these questions earlier in the chat, but do you have to pay for their time to get tested? It depends. Number one, if you are an employer who's testing them on site during the workday, yes, most likely. That would be under the FLSA part of your workday. And then, but if you're just requiring employees on their own, then you may not, but you should check state laws. And if you have a collective bargaining agreement, and there is potentially supposed to be more guidance coming out on this.
Yeah, Damien, I'm just going to interject there real quickly. I mean, I think the one issue becomes is if you're requiring employees to get tested, I mean, that essentially could potentially be construed as a work requirement. So the time that they're doing that, they're performing requirements for their job. I think that potentially could trigger an obligation under the FLSA. I think it's a real dicey issue. And the thing that's tough is that the OSHA rule in the ETS says you don't have to pay people for their time testing, but OSHA doesn't regulate that. That's what OSHA regulates the OSHA Act. It doesn't regulate the wage and hour issues, which is the wage and hour division. So I would be careful about just taking the ETS at face value that, oh, I don't have to pay employees for their time getting tested. I would really think about that and analyze that with your legal counsel about the risks.
So that's what's meant when you see in the OSHA regs, check other laws and check state and local laws. Idaho doesn't have these, but if doesn't typically have anything for leave, but if medical testing is part of your requirement that needs to be paid, then that would be paid time, and it's safer just to pay it as paid time. Okay, next slide. So the log, you have to ask all employees and collect all employees' information. You have to maintain and create a log, and it may be inspected. You do have to keep copies of documents, and that's copies of people's vaccination status and people's testing when and if you get there. They are considered to be medical employee records, but there's under some statutes, you're supposed to keep those records for 30 years. The ETS specifically says that in this case, you only keep them while the ETS is in effect. And I think OSHA has made the guidance in the Federal Register makes a big point of maybe this will only be in effect for 6 months too. And then the ADA requires you to keep your employee medical records, if you're in HR, you know this already, separate from your HR files and only accessed by the few who need to know that information. So you're not giving everyone, for sure, specific people's test results or specific people's vaccination results, but you do have a responsibility to give that to the individual employee who asks for it. And then the aggregate number will be, I want to say discoverable, but any employee can ask for the aggregate number. How many people are in my workplace and how many people are vaccinated in my workplace, my specific workplace. And those numbers have to be given by the next day. And then OSHA can ask that information too. And that's one of the quick ways that OSHA is going to kind of see if you're in compliance, is just check the log or just check these numbers.
Amy, by workplace, so for employers like Amalgamated that have various factories, offices, facilities, would we just be required to provide that employee's specific site or in company-wide?
For that, it is specific site.
Okay, so it needs to be logged by location.
Yes.
Okay.
So then, in talking about the testing alternative, you can have a policy, as I said, that just requires vaccinations, or you can have a policy that requires vaccinations or testing. And this was put into place as something of a replacement because it's seen to now be a better mitigation measure, right? When we knew less about how the disease is transmitted, and now that more people are vaccinated, the best option now is to keep the workplace safe is vaccinations. So instead of getting your symptoms tested and your temperature tested, OSHA believes that catching the pre-symptomatic and asymptomatic cases will help bring down numbers, you know, countrywide, probably workplace-wide, and will help individual employees get early treatment. The tests that are required are the only, you need to look into the regs and see the precise wording on the test. You cannot have it be both self-administered and self-read. So you can't, I have one right here. You can't just take one of your tests that you have at home that you can order from Amazon for, you know, depending on what time of, this is probably much more valuable now than when the ETS went out last week. But you can't just take one of these at home and say, yeah, I'm all clear. So if you're going to do what they're requiring is, I think it's called point of care tests are okay. PCR tests are okay. The antigen tests are okay, but you can't administer it yourself and read it yourself, because then there's no accountability. The minimum frequency of testing is 7 days for the unvaccinated. And so the employee should get a bring in on the day they come to work, the test result every 7 days. So the suggestion was employers could help out with this by setting up a day, like everyone is tested on Wednesday, or, you know, stagger testing days, but have the individual employees have the same testing day each time, so that there's a routine. And then we talked about when teleworkers have to do it. And we've talked about this already in part. So OSHA says you're not required to pay costs associated with the actual testing. Make sure you check what your collective bargaining agreement says. You can volunteer to pay for testing. The guidance actually suggests you may want to do this as to make you a more, I don't know, attractive employer in this horrible market, which I think might really annoy a lot of employers. Like, thank you for giving me all these new regulations, and oh, thank you for suggesting that maybe I should also pay for everyone's testing. So there's also a requirement that each employee has to promptly notify you as the employer when they are COVID positive. You have to remove them from the premises, and paid time off is not required here. And then once they're positive, you don't have to continue to test. And then you should follow the return to work guidance, which is, it's in the guidance, but it's just the standard CDC return to work. So it's like 10 days, symptoms are improving and no further symptoms or something like that. Next slide. The other thing that you have to do in addition to testing, if people are not vaccinated, is masking. So, and employers have to ensure that the employees who are not fully vaccinated wear a face covering when they're indoors and when they're in a vehicle with another person for work purposes. The exceptions are when you're alone in a room with the door closed, when you're eating or drinking, but that's for a limited time, and then, or when it's infeasible or creates a greater hazard. Next slide. I've included this OSHA reporting information because I've gotten questions on this before in presentations, but I want to jump ahead to give Sean more time. But just I've included the information to look at if you do have a reporting, and there is now a reporting requirement to report to OSHA if you have a positive case.
Okay, thanks, Amy. There's a couple of questions I just want to address real quickly, and I've just been skimming through. One of the questions was, what should employers consider if switching employee status from employee to independent contractor to avoid discounting requirements? And I would answer that, be very, very, very careful if you're going to do that. You have to change the nature of the relationship. You have to change the nature of their working. That's going to be seen as being transparent. And the Department of Labor has been very vigorous in cracking down on employers or companies who treat workers as independent contractors as opposed to employees. So I would be really, really, really careful about doing that. Okay, so I'm going to try to be really quickly and blow through these slides to make sure that we have some time to hear Christina's perspective at her workplace. So there's two exemptions essentially from the vaccination and potentially the testing requirement, although I haven't really seen any kind of claims on the testing. And those exemptions are a disability or a religious belief. Disability is easy. We've all dealt with ADA accommodation requests with regard to disabilities. So if someone says, I can't take the vaccine, or in a very unusual case, I can't be tested, which again, I don't know of any situation where you can't get tested because of a disability, but if that happens, then you can require a certification from a medical provider that the employee does in fact have a disability under the ADA, and that the employee can't take the vaccine because of the disability. I know, for example, that Guillain-Barré syndrome has been identified as a syndrome of people who have that should not be taking the vaccine. Okay, here's the harder one, and all the stuff we've told you about today, it's pretty straightforward. I mean, it's dense. The ETS is 494 pages, but it's pretty straightforward. This is where you're going to have the most questions and the most difficulty in trying to decide what to do, and that is when employees claim religious exemptions. Let's just kind of talk about the groundwork. An employee must have a sincerely held religious belief that taking the COVID-19 vaccine is against their religious belief. What is a considered sincerely held religious belief is very, very squishy. And cases talk about that it's the dreaded case-by-case analysis. You know, when courts say, we decide this issue on a case-by-case basis, that means that the courts aren't giving you real good guidance about, you know, how to interpret their rulings or how to handle these situations in the future. They're just saying on a case-by-case basis. And of course, each case has different facts, and so the precedential impact of a particular decision is not as great as it otherwise would be. Next slide. So here's just some quick guidelines or kind of references to what courts have said about religion. Religion includes all aspects of religious observance and practice as well as belief, not just practices that are mandated or prohibited by a tenet of the individual's faith. It includes not only traditional religions, but also beliefs that are new, uncommon, not part of a formal church or sect, only subscribed to by a small number of people, or that seem illogical or unreasonable to others. It is a belief is religious for Title VII purposes if it is religious to the person's own scheme of things. It is sincere and meaningful belief that occupies a place in the life of its possessor parallel to that filled by God. You know, you look at that language in those cases and you think anything could be a religious belief. But there have been some courts have attempted to kind of put some kind of boundaries on what constitutes a religious belief and what does not. Some of the language some courts talk about the religion typically concerns ultimate ideas, such as about life, the purpose of life, and death. Other courts talk about a religion addresses fundamental and ultimate decisions having to do with deep and imponderable matters. Second, a religion is comprehensive in nature. It consists of a belief system as opposed to an isolated teaching. And third, a religion often can be recognized by the presence of certain formal and external signs. So those are kind of some of the guardrails that we have that courts have put in place to say, you know, not everything an employee says is religious. But again, it's very, very squishy and it's decided on a case-by-case basis. So it's a hard issue to deal with. Next slide. Okay, so go back one. Okay, religious exemption, when can you ask? So essentially, if you have an employee that comes to you and says, hey, I can't take the COVID-19 vaccine because of my sincerely held religious belief, and you have an objective reason to believe that that is not accurate, then you can start inquiring and asking questions. Some of the things that might tip you off that this isn't really a sincerely held religious belief is, for example, if the employee gives you a form letter that you can find on the internet. The vast majority of religious exemption requirements that I've been dealing with and representing clients is these form letters that someone wrote, and everyone on their Facebook group says, hey, if you want to not take the vaccine, use this letter. And it's this form letter that you can find on the internet. And they copy it word for word. One of my favorite ones was an employee used a form letter, and it said, and then it had a blank space for the name of the employee. She didn't even bother to fill that in. She didn't bother to fill in and said, so-and-so employee. She just left it blank. So it was obviously that she's just copying and pasting from the internet. Another telltale sign that might make you suspicious if they're talking about only the COVID-19 vaccine and not giving you a broader context of a bigger belief system. A religion is not just a single issue. There is no religion saying, I do not want to take the COVID-19 vaccine. That's not a religion. That's a single belief. It's a single teaching. So religion has to be more comprehensive and complex, as we talked about on the earlier slide. So that's another potential red flag for you that makes you think maybe I should, inquire more. For example, another example might be you have a letter from a pastor saying that I, recognize and respect this employee's religious beliefs. It doesn't talk about what the actual religious belief is. Another one that I've seen floating around is someone saying that the COVID-19 violates the Nuremberg Code. Well, that has nothing to do with religion. That has nothing to do with religion, but you see it a lot of times. Okay, what can you ask? So someone says, I have a religious belief that prevents me from taking the COVID-19 vaccine, and you do some inquiries and you have objective reason to think, this might not be a religious belief. What can you ask? Some of the things you can ask is you can ask verification from a religious leader. You can ask for documentation about the religious belief. You can ask for information or to talk to other people who might verify that the employee holds that belief. You can ask the employee whether there are rituals or other aspects of the belief system. You can ask the employee when did they first believe or have this belief system. You might maybe ask specific COVID-19 inquiries, such as have they verified that they have never taken any vaccine, verified that they've never introduced quote unquote unnatural elements in their body, which is a lot of times what you see in these exemption requests is I don't introduce unnatural things into my body. Well, verify that. Has that always been the case? Have you never taken a vaccine? And one of the big ones that's coming out now is that people are saying these vaccines were developed using fetal stem lines, and I have a religious objection to fetal stem lines. Well, there's a whole bunch of products that almost, I guarantee you, everyone takes that were developed with fetal stem lines. And so one of the things you can potentially do is identify those products and say, can you verify that you've never taken any of these products? Those are some of the things you might want to consider asking if you want to verify an employee's stated religious belief. And these are some of the factors the EEOC has said you can weigh when looking at credibility. Has the employee behaved in a way that is markedly inconsistent with the religious belief? I mean, are they always downing, medicine or taking other vaccines, getting the flu shot, and now they say, well, I can't introduce a foreign element into my body, but they've always gotten the flu shot. Whether the timing of the request indicates that it's suspect. So in other words, maybe they asked for a disability exemption that was denied, and so then they came and they found religion, and they said, okay, not a disability exemption, but a religious exemption. That timing is going to be very suspicious and is going to weigh against the employee's credibility that this is actually sincerely held. And again, I apologize for talking fast. I'm just trying to get through these slides real quickly. Whether you have other reasons to believe that the accommodation request is not valid. Next slide.
Hey, Sean, can I ask a quick question? We're getting a lot of comments about this religious medical exemption, and some employers may choose to grant them more freely and not look into it too deeply. What obligation, because this is an OSHA mandated thing, does an employer have to make sure or verify that the exemption request is legitimate? Will OSHA be
that is a great question. And what I would suggest to you, for example, I mean, you know, all I can give you is kind of the paradigm, the outside paradigms that would be the clear-cut answers. For example, if you got a religious exemption request and says that, you know, this is against the Nuremberg Code says that you shouldn't introduce, or and I can't remember exactly what the language is, but they base their whole thing on the Nuremberg Code. Well, that's not a religion. That's a political statement. That's clearly not a religious exemption, a legitimate religious exemption request. So if you get something like that, then I think you need to start looking and start delving a little deeper. You know, but generally, if the employer does not want to delve too deep, the EEOC in case law has said that generally you are to presume the validity of the stated religious belief. And again, only if you have an objective criteria for disputing it and for not challenging it can you do that. And so my advice would be is that if you have something that clearly looks like it's not sincerely held, again, talking about Nuremberg, again, maybe just copying and pasting something from the internet, I would in this instance, because it is OSHA mandated, I would delve a little bit deeper. If it wasn't an OSHA mandate, you would be free as the employer based on, I think, Supreme Court case law and EEOC guidance to say, well, they stated it, I'm going to believe it. But given the fact that this is an OSHA rule, I think you run the risk of just accepting anything that comes through across your desk as being a religious exemption. If you accept that without any kind of inquiry, clearly things that are clearly do not appear to be sincerely held, and you don't do some kind of inquiry and you don't document the inquiry you're doing, you could have an issue. And I don't know if that clearly answers the question, but that's kind of the how I would respond to that is that I don't think you can just take it at face value if it looks off, for some of the reasons that I've talked about earlier. I think you have an obligation to investigate things that are clearly suspect, which you might not otherwise have in other kind of contexts where religious accommodations are requested. But this is different because, as you said, Christina, we've got the OSHA rule. So the last couple of slides is that as you're going through this accommodation, you're deciding whether to grant the accommodation, you need to go through an interactive process. And the accommodation will not be required if granting the accommodation. So in this case, not letting the employee get the vaccine would pose a direct threat to the employee, would pose a direct threat to coworkers, would pose a direct threat to customers or clients, cause an undue burden to the employer. I think particularly if you have an employee who has been working from home or has been telecommuting and says, I want, that you're going to have a hard time saying that, that continuing that request as an accommodation for them not getting the vaccine or not getting tested, you're going to have a hard time. And particularly in the fact that when the ETS says that people that are working from home are generally not required to be tested. So if you are essentially, you've let people work from home, you want to bring everyone back, and the employee says, I don't want to get the vaccine, and you say, well, everyone needs to come back to work, and the employee says, well, I don't want to get that vaccine, so I can't interact with other people under your rules, let me work from home, you're going to have a hard time saying, well, that's not a reasonable accommodation, it's going to cause me an undue burden. Okay, next slide. So I think we can skip this one. Next slide, Jason. Okay, so the last thing is that you can kind of get out of this is saying that it constitutes an undue hardship on the employer, and the test for that under Title VII is a lot lower than it is under the ADA. I know that we're over time, but I appreciate you staying on. I want to ask Christina. I know that I would appreciate everyone's indulgence. We just go a few minutes over. I just want to ask Christina, what issues have you been dealing with at Amalgamated in terms of vaccinations and testing, and how do you plan to respond to this ETS requirement from OSHA? What are some of the considerations and the issues that you've been dealing with at Amalgamated?
Yeah, thanks, Sean. And I know we're running out of time, but I hope I've answered at least some people's questions in the chat as to what we're doing. But it's a tough world out there. This is not an easy time for OSHA to be issuing a mandate like this. Amalgamated, like I'm sure every other employer on this webinar right now, is competing in a very tough labor market. And Idaho has a low vaccination rate. We also have facilities in Utah and Oregon And the general sense from our employees is they don't want a vaccine mandate. And in a labor market that we're in right now, we don't want to risk enforcing a vaccine mandate, losing employees when we need to keep our factories running, and we're already running very, very lean because labor is short these days. So because of that, we're moving towards the optional vaccination and mandatory testing scheme. You know, there's a lot of reasons for that. Another one is our factories are unionized, and all of this will be a condition of employment, obviously. But testing just is a better alternative for us. We will continue to incentivize vaccinations. Currently, we offer a $1,000 incentive for employees who do become fully vaccinated. We adopted that about 6 weeks ago, and we have seen an additional 204 new employees vaccinated, and before that we were only at about 400. So that's worked really well for us, and the more employees we can get vaccinated, the more money we'll save on testing. So our company and our board has been very supportive of that. And then just generally, I know there's a lot of questions on this, but logistics is a huge consideration for us. How do we get employees tested? And there was a question from someone in the chat, John. This ETS has been challenged. So, you know, do we spend $1 million purchasing testing kits now? Do we wait to see what happens with the ETS? These are things that we're considering and trying to map out the timing when virtually every large employer in Idaho and in this country is going to be trying to mass buy rapid tests. So one model we're looking at, we're not sure if we're going to be able to go this way, but there is a pooled testing model where, you know, 10 employees can all provide saliva samples, and then the employer can send it out to a lab and test. If the pool comes back negative, not all those people pass. If it comes back positive, all of them have to submit to a nasal swab or something. We think that will help a lot with logistics, not having employees have to show up 15 minutes early for a shift. But it's tough. It's not easy for employers, especially in this labor market. So.
Okay. Thank you.
Mm-hmm.
Well, I think I know we're out of time. Again, if we weren't able to answer your question, please feel free. We will be sending out the slide deck. And if you have a specific question, you can email Amy or I your question, and we will do our best to answer it. And if we don't know the answer, we'll try to figure it out. So thank you, everyone, for attending. We really appreciate it. And you know, this is kind of an interesting issue that, as Christina talked about. I mean, what do you do with this ETS being challenged? I mean, my view is, and this is, you know, just my opinion, nothing, you know, it doesn't hold any weight per se, but I think that you run a real risk if you think that the ETS is going to be completely eviscerated by courts. I think it's going to survive. And so it's just going to be a matter of when, you know, if there's court delays, whether there's any kind of enforcement, you know, continuance or extension of the deadlines. But in my view, and again, this is just me talking, I'm not an expert, I'm not the judges, but I think that the ETS is probably going to survive the challenge. So.
Well, thank you very much, Sean, and a big thanks to all of our panelists, Christina Hardesty and Amy Lombardo. And I'd like to extend a big thanks to all of you for joining us this morning. We recognize that this is a complicated issue, and we urge you to consult with legal counsel before you make any decisions on this. As Sean mentioned, please feel free to reach out to Amy or Sean if you have any questions or if we can provide further guidance. And as we mentioned throughout today's presentation, the PowerPoint will be sent to you via email, and we will also provide you with a link to the recording so you can rewatch this or share this with your respective teams. So again, thanks for joining us this morning, and we wish you all the very best. Take care.
All right, thanks everyone.